Our speaker today is Dr. Marc M. He joined the UCL Law Faculty in 2009, having previously lectured at University of Bristol. He's a visiting faculty member of Seattle University of Law, where he's established a graduate course in comparative company law. His research interests cover company law, corporate governance, and capital markets, especially the theory of the firm and legitimacy of managerial decision-making power in public companies. He's content editor of Tolley's Company Law and Rutledge's Company Law Statutes, and is currently writing a book with Hart Publishing called Corporate Governance in the Shadow of the State. Today he's going to present an aspect of the forthcoming book with his presentation, which you'll see is Beyond Private Ordering, Rethinking Corporate Governance as a Subject of Legal Inquiry. Marc, thanks. And Marc will just half an hour, 35 minutes?
Yeah.
And then we'll go with questions after that.
Excellent. I've probably got too much material, but
That's fine.
I'll try and cram it in. First of all, thanks to Professor Cheffins for having me over today, and thanks to everybody for coming out and giving up your lunch at this very busy point in term. I appreciate that. Just so I know where everyone's coming at this topic from, is everybody here a corporate governance person or corporate finance? Who's the corporate governance people here? Most people, right. So, who's the corporate finance people here? Same people, right. So, half of you, probably a bit more than half of you will know where I'm coming from. Okay, I, like Brian does here, I teach corporate governance at UCL to our graduate students, and I've been working on a book now for the last couple of years, which, touch wood, should hopefully finish this summer, barring an unforeseen catastrophe. And what I want to talk about today is I just really want to throw around a few ideas which I've been working on in this book to try and get a sense from intelligent, informed people whether it's a load of nonsense or whether I might actually be onto something with them, really. So that's why I'm here today. What I want to talk about is corporate governance. Corporate governance, I was just talking to Brian about, I'm sick of it. I'm sick of talking about the financial crisis. I'm sick of talking about corporate governance as a subject, which is a bit of a bad situation to be in when you teach the subject. We seem to be getting so much material in this area, it's very hard to keep up with it. And anything that happens in the business or financial world, you can kind of latch corporate governance onto it and find a corporate governance issue in that, which means there's just so much stuff being written in this area. So corporate governance is everywhere. And does anybody really know what it means? Because the term is thrown around. Different people use the term to refer to different things. So we've got so many specialist courses and texts in corporate governance, some better than others, in both business and increasingly law schools, obviously including this one. There's also growing professional specialisms in the field of corporate governance, things like proxy advisory agencies and corporate governance ratings agencies, even arguably might even come close to rival in traditional professions like law and investment banking at some stage. And also corporate governance, as I said, it's constantly evolving, it's further in the spotlight. Now I think there's some common misassumptions we make about corporate governance. We think of it as being dry and procedural. It's just a load of codes and committees. Some people take that view of it. It's a very bureaucratic subject. Not a lot of intelligence is involved apart from just reading codes. You don't really have that much case law, hard doctrinal analysis to occupy your mind. Some people see it as not really being relevant to law at all. It's just about economic efficiency or business performance. It's something for business or management skills to bother with, not really something for lawyers to get interested in. And another attitude, which a number of lawyers actually have, is it's not really proper law. It's not proper company law, it's just the easy theory stuff. Certainly my former head of department at UCL, who'll remain nameless, used to frequently say to me, "Moore, when will you stop doing that rubbish corporate governance and start doing some proper hard law?" It was a tongue-in-cheek comment, but I think that attitude is shared by some people. So what I really wanted to do with my work is to try and dispel some of these prejudices about the topic. So what actually is corporate governance? Sorry for big quotes and slides, but I needed one for this. This is my definition of corporate governance. Corporate governance legally defined, not economically defined, legally defined. The social problem of holding key decision makers in large economic organisations accountable for their actions, or otherwise legitimising the possession and exercise of power within liberal democratic society. I think that's a definition of corporate governance that stretches beyond the traditional, fairly narrow agency costs understanding of the subject that we see in law and economics literature frequently, and tries to incorporate other political and overtly legal dimensions into the topic. So that's the definition of the subject that I tend to base my thinking on. And ultimately, as you're aware, corporate governance is concerned with the balance of decision-making power. In large companies, in the Anglo-American environment, we normally focus corporate governance thinking of public companies because of the peculiar problems public companies pose, such as the Berlin-Means problem, the separation of ownership and control. No, it's not important in closely held companies, it's just different issues are obviously posed in that environment. And corporate governance focuses on the legal rules and also other influences. As we know, in corporate governance and corporate finance, law can never be viewed in isolation. It operates within a wider framework of pressures and structures, market forces being an important category. And just to reiterate the point I made earlier, corporate governance at the very bottom point, the two words in pink are the ones I try to spell out to students constantly, especially at the start of the year. Corporate governance, in my view, is principally aimed at achieving these two things: accountability and legitimacy of private economic power. I always throw the question out to students in the first corporate governance class of the year: what are the two words that best sum up corporate governance from a lawyer's perspective? And constantly I get the same answers every year: efficiency, performance, profits, wealth. Not one person ever mentions either of these two words, accountability or legitimacy. So I'm not saying corporate governance isn't relevant from an economic point of view, far from it. But I think sometimes a strict economic focus misses some of the bigger picture that should be of concern, I think, to lawyers, and that's really what I'm trying to demonstrate. Now, as we know, any subject to learn any subject, to teach any subject at a rigorous intellectual level, you need something called paradigms, or, for want of a better word, theories, although I don't think the two words are quite equivalent. But every subject really needs a series of paradigms. What is a paradigm? It's one of these words that I frequently use, and up until recently I didn't really know the meaning of it, it just sounded good. A paradigm, I think, is a kind of lens, a conceptual lens, which we look at a subject or a phenomenon through, and it structures the way that we see that thing, the way that we understand it, how we identify problems in it, and also how we as teachers teach the subject to students. And in a way, a paradigm creates a narrative or a story to help you understand the topic. Corporate and commercial law generally would be a horrible subject to learn if it was not for paradigms, because we would just be stuck with a voluminous body of rules and no real thread to hang it on. Now, in the field of company law generally, and specifically corporate governance, we have one particular dominant paradigm which I think most people will have come across and be familiar with, which is namely the contractarian paradigm, or it's sometimes called the nexus of contracts theory of the company. And it says a number of things which some people will already be familiar with. Corporation is effectively just a nexus of contracts. Companies are created voluntarily through contractual negotiations, contractual bargaining. Law is there, laws exist. Contractarian does not deny the existence of law, but the law has a principally functional, facilitative purpose. Laws are passive instrumental. They're tools that people use in the business environment to achieve their own ends. Law should not coercively tell people what to do. It should not change their normal patterns of behaviour. It should facilitate their own prudential individual choices. And that's a common way that we conceptualise laws in corporate and commercial law generally, I think, especially in this field. And we see a number of preferred characteristics of law within this particular paradigm that we often don't see in other areas of law. So, for example, laws, according to this conception, most contractarian scholars would say laws should be freely reversible. We can opt out of laws that don't suit us. Corporations can choose not to be subject to laws that impede their flexibility, their freedom of action. And investors ultimately select corporate rules, or perhaps corporate managers select what rules they want the company to be subject to with a view to pleasing investors and attracting investment, reducing the company's cost of capital. And generally, but not universally, but generally the contractarian paradigm tends to emphasise the goal of shareholder exclusivity or shareholder wealth maximisation. The commonly accepted, especially Anglo-American notion that the core objective of the company should be to generate wealth for shareholders to the exclusion of other concerns. You don't have to subscribe to that view if you're a contractarian. It's just generally speaking, that's what contractarians see as the contractually determined objective of the company. So, all in all, what contractarianism, I think, tries to establish is it tries to categorise corporate law as an aspect of private law, facilitative law, in distinction from the other category of law, regulatory law, or for want of a better term, public law. I don't really like using public law in this context. I don't mean public law in the state law sense. I mean public law in the criminal law type sense. Laws that actually coercively try to change behaviour. Corporate law is very much put in facilitative law category rather than regulatory law category, and I think that's how most people understand the subject. Now, there's a number of landmark contributions to this line of scholarship. I'm not going to go through them all. I have mentioned Professor Cheffins because I think he deserves to be in this category, not least because I think his book in 1997, Company Law Theory, Structure and Operation, was the first book to actually take this field of scholarship, largely from United States law and finance theory, and comprehensively apply it to UK company law. And there's a few more seminal contributions from earlier years as well on the list. Now, contractarianism, I should be able to say the thing that I'm writing about. It's not just a kind of highfalutin academic concept divorced from reality. It is influential in real life, and it's been influential in policy making as well. So there is a real point to this discussion. Those of you who studied UK company law will be aware of the vast changes that took place in the lead up to the changes that took place under the 2006 Act, the longest piece of legislation in British history, I think. And these were three phrases that the Company Law Review Steering Group that the government appointed to consult on and devise the proposals underlying the Act. This is three aspects of the basic philosophy that underpinned their thinking. And I won't recite them, but you can kind of get the gist of where they're coming at the subject from. The word flexibility is mentioned 2 or 3 times. The notion of laws as being flexible. Intervention, regulatory intervention should be avoided unless strictly necessary. And ultimately the purpose of law is to facilitate effective business choices. So it's all about facilitation, flexibility, trying to avoid coercion whenever possible. Very much a contractarian philosophy. Now, what's problematic? Now, before, lots of people bash the contractarian theory, and I don't want to do that. I think there are certain problems with it, but at the same time, I'd much rather live in a world where we have this thinking than we don't have it. Not least because, as I said earlier, it makes teaching company law and corporate governance so much easier when you have a structure, a logic, a narrative to hang the topic on. Contractarianism presents corporations and laws as evolving in a kind of organic bottom-up way. People form businesses, they choose what structures they want, they opt into those structures, and they do so voluntarily, like the classic video store example in Professor Cheffins' book. And I think that's an intuitively more attractive way to study law than looking at law in a kind of coercive top-down manner. This all-powerful state tells businesses what to do, the notion that's more common in the civil law tradition. So there's intuitive appeal to it. I think there's some difficulties, I think there's some tacit things that contractarian theorists kind of take for granted, and I don't box everybody into this category in that school, but I think many do fall victim to these issues. Contractarianism, I think, tends to assume that corporate law is facilitative and therefore politically colourless. There is no real hard political motivation to corporate law. It exists outside of the public policy sphere. Also, a dichotomy that Milton Friedman drew in the 1970s in his neoliberal scholarship. Corporate law, he didn't say this expressly, but his thinking illustrates this point. Corporate law is there to to achieve what Friedman called unanimity. It's the second word I can't say today. Unanimity in social relations, as opposed to conformity. What that means, unanimity, is everybody is free to opt into market relations that suit them. They don't need to be held to any particular arrangement that they don't prudentially want to be part of. Unanimity tends to pervade in the market sphere, conformity pervades in the political sphere, and conformity should not be applied to market relations. And I think that's an important presumption that many contractarian scholars make in this field. Also, it's assumed the notion of corporate power. This is where we start getting a bit woolly and theoretical. What is corporate power? It's a very opaque term. Lots of people understand it in different ways. Contractarian scholars and students tend not to think of corporate power as being a major social or political problem because it's privately resolvable. There's the notion of agency costs, the private costs, private aspects of power that arise through voluntary arrangements, for example, between managers and shareholders. Shareholders can devise appropriate mechanisms to keep managers under control, whether it be independent directors, performance compensation, other ways of holding managers to account. And as long as managers are accountable, then generally speaking, the power they exercise is not perceived to be socially problematic. And finally, a last point, the concept of the public interest in economic organisation. What the German company lawyers call Unternehmens Interesse. We don't really have a word in the English language that quite means the same thing. The public interest in corporations. There is no public interest in corporations, really, according to this mechanism, or if there is, it's diffusely established through market transactions. Nobody defines what the public interest is when it comes to the corporate law sphere. So that's, I think, a few political implications of the contractarian position. And because corporate lawyers don't tend to talk about politics that much, I think some of these things often get swept under the carpet, particularly in a lot of the American corporate law scholarship. And as I said, this isn't just a highbrow, impractical discussion. The contractarian model permeates into so many areas of corporate law. Admittedly, it's more relevant in the United States because in the US there's a much greater tradition of reversible rules. People can opt out of rules that they're not happy with. Classic example of an opt-out rule in the United States under state law, which in the context of public companies largely means Delaware law, of course. Under Delaware law, we have exculpation provisions. A director can be exempted from money damages for breach of duty of care, not for fraud, but for negligent action, which means that if you are liable for negligence and there's an exculpation provision in place, you will not be liable for money damages. We don't allow that in the UK. But in the US, it's a classic example of opt-out. It's manipulating the law to suit individual prudential purposes. Because otherwise, the theory is managers wouldn't be inclined to take risks. Also, there's a few other aspects of the US model that kind of affirm this contractarian view. I'm not going to go through them all, because most people will be fairly familiar with them, or basically familiar. You'll probably be more familiar with the aspects of UK law. There are a number of aspects of UK law that also provide empirical validation for this contractarian viewpoint. And again, I won't go through them all. The most literal example is the rules of law, which state that the articles of a company, the constitution of a company, has contractual status. And also much regulation that exists in the UK, as we probably know, such as the UK Corporate Governance Code and the Takeover Code, are not hard law in the orthodox sense. They are what's best called market legitimised regulation. Regulation that's accepted by market actors, albeit with a bit of help from regulators, but generally market-based rather than state-based regulation. And I'm sorry for flicking through this so quick, but I can circulate slides if anybody wants them. Now, there's been a bit of controversy over recent years. Some people, more in the States than over here, not so much in the UK actually, have been up in arms about what could best be called the deprivatisation of corporate governance law, and certainly in the US, arguably in the UK too. The biggest phenomenon, regulatory phenomenon in US corporate governance over recent years, especially post-crisis, has been a trend of federalisation, as some people have seen it. Sarbanes-Oxley, the big post-Enron regulation back in 2002, was one such example, and also Dodd-Frank, the post-crisis Act. Both of those acts don't concern corporate governance, except to a minority extent, but nevertheless they have some important implications for corporate governance. And the reason they're so controversial is because they're federal in the United States. They offend the idea of regulatory pluralism in the US system. In the US, there should be 51 different systems of law, and corporations should be free to choose which of those law shops they'll go to buy their law, in effect. That's how the US system works, because of free interstate incorporation. Federal laws take away that pluralism, take away that choice, bring greater rigidity and coerciveness. In the UK, we don't have these concerns because, for most intents and purposes, we're a unitary system, except in the EU dimension, obviously. In the UK, I think the biggest issue concerning a deprivatisation of corporate governance law would be a trend that we could call juridification. In other words, more and more issues that were previously dealt with on a fairly flexible basis under broad common law or equitable principles have been incorporated into statutory codified form. And directive duties is, of course, a classic example of that, as the company lawyers will know. And another example of juridification, in other words, concretising formerly flexible principles, putting them in a formalised, rigid way, is the impact of EU harmonisation measures. The Takeover Directive being an example of that, although fortunately the UK was able to preserve the bulk of its flexibility in its system of takeover regulation even after the harmonisation initiative. Now, I would argue we're not really witnessing any sort of deprivatisation trend because corporate law, corporate governance law in particular, has always been heavily regulatory. It's just that we've conveniently kind of smokescreened that and presented the subject in a slightly different way from how I believe it should be seen. There's a lot of examples of what, for want of a better term, I would call shareholder protectionism, which means that the state provides mandatory regulation to protect shareholders of public companies, to protect them from the adverse exercise of managerial power. And the classic example of this type of law is disclosure regulation. Mandatory disclosure regulation is widely accepted as structurally essential for private ordering. So if investors and managers are going to choose how to structure their firm, what structures, what institutions, what laws will apply to their firm, the investors need to be in an informed position. They need to know about the firm, they need to know about the firm's performance, they need to know how its performance compares to other firms in the market. How can they do that? Most people would accept, even most contractarians would accept, that we really need a bit of mandatory disclosure regulation to ensure that. Because private mechanisms of information finding in securities markets are limited. Because information is what Easterbrook and Fisher have called a public good. It's something that nobody has really got the incentive to pay for to an extent that benefits everybody, makes everybody rational. However, corporate lawyers conveniently kind of brush this stuff away. They say, well, that's just securities law, or capital markets law, as we would say in Europe. Therefore, we can kind of brush that out of corporate law, as long as we keep corporate law flexible and facilitative. It doesn't matter if there's a bit of regulatory stuff at the periphery, in areas like securities law or labour law or criminal law, tort law, etc. Now, can we do that? I would argue no. Many aspects of securities law, and again this is where I'm going more into Professor Ferrer's area than my own, bit out of my comfort zone, but many aspects of securities or capital markets law challenge the logic of this distinction, I think. For example, proxy rules in the United States are absolutely central to corporate governance, but they stem from securities law rules, mandatory regulatory rules. Anti-fraud rules as well, I think, are a classic example of a corporate governance mechanism hiding in securities law. And also comply or explain People think of the UK Corporate Governance Code as being flexible. It is, but it's only flexible because we've got a mandatory listing rule that tells people they must disclose their corporate governance compliance. And another point as well that's important, mitigating the informational disparity between managers and shareholders, making shareholders, or I should say investors, more rational and informed. That is in itself, in my opinion, a political distributional policy. It's not something that's just a technical necessity of securities markets. It's heavily underlain by political factors as well. So that's why, in my view, and I'm very much open to be counter-argued on this, I don't think we can conveniently sweep away these aspects and say they're not relevant to corporate governance. And if we look at the UK, I think there's even more evidence to say that this view of the world is maybe not quite comprehensive. Shareholders' ability to intervene in corporate decisions, for example, by dismissing the directors, even though they would very, very rarely do that in a public company, or by getting involved in the proxy process around the company general meeting. These are all regulatory mandatory statutory rules. Also, directors' duties in the UK, unlike the US, are non-derogable. You cannot get out of them. You can have ex post facto liability relief, but that's not the same as actually getting out of your duties. You cannot exculpate yourself. And also, the fiduciary doctrine, the idea that managers, or I should say directors, are accountable to shareholders, which lies at the heart of the agency issue in the contractarian view. Ultimately, this stems from the fiduciary doctrine, the common law, or I should say equity. It's an equitable doctrine, the fiduciary doctrine. But if you look at the case law on the fiduciary doctrine that lies at the heart of the shareholder-management relationship, one of the key phrases that the English courts always emphasise is the inflexibility, the rigidity of the fiduciary relationship. The idea that directors cannot not be fiduciaries for shareholders because it's absolutely central to their status. So I think there's a lot of issues with this sort of flexible, facilitative picture of the law that so many people try to paint. Why are contractarians unhappy with, I won't say unhappy, but why are they uncomfortable with mandatory rules? According to contractarians, mandatory rules are irreversible, they're immutable, so they're rigid, they're cumbersome, they're clumsy, they're unwieldy. They're also unsusceptible to bargaining and pricing, which means mandatory rules are much more likely to exhibit inefficiencies than flexible rules. And there's also political concerns as well. Arguably, mandatory rules are more subject to politicisation. Lawmakers can be captured by dominant interests. I don't know if that concern is so prevalent. I don't know if it's so valid, because we know from the US Delaware experience that flexible rules can be subject to capture as well. And also, mandatory rules are prima facie coercive. They promote state imposition over decentralised private ordering. So in a way, they undermine the basic neoliberal division between the state and the market. The state permeates more and more into the market, which poses political problems from that perspective. But that's not to say contractarians won't accept mandatory rules. They will do. But they come up with very, very clever rationalisations as to why we should have mandatory rules. So, for example, Stephen Bainbridge, in his book, The New Corporate Governance in Theory and Practice, a few years ago, advanced the take it or leave it argument. Mandatory rules are never mandatory because you can just leave jurisdiction, you can just incorporate your company elsewhere, or if it's securities laws, just list them in another market. That's one argument. Other argument, classic argument to support mandatory rules from a contractarian perspective is Bernard Black's classic view. Mandatory rules are market mimicking, which means they're politically trivial. In other words, all mandatory rules in corporate and securities law do is they provide the solutions that we as transactors, that we as investors would be inclined to choose if we had full competence and full rationality. The fact is, as human beings, we don't have full rationality, so the state just steps in and mimics what we would do as ideal contractors. That's politically trivial. It's just a rational response, but by the state rather than the individual actor. And I think that's a very influential argument. And there's also the market failure rationale. summed up by Geoffrey Gordon's phrase, mandatory rules lead to better contracts, which kind of overlaps with Black's argument a bit. Shareholders, well, basically corporate law is too damn complex for people to get their head around. We need the government to give us a bit of a hand, because private mechanisms of selecting rules are simply not advanced enough to do without mandatory state involvement. So that's how these rules are rationalised within that view. What are the limitations of this view? Just to very briefly go over them. Limitations of the take it or leave it argument. I don't think it works very well outside the United States, where you have a unitary, non-federal system. It kind of breaks down, I think, when you have major barriers to reincorporation interstate. Even in the European Union, where we certainly don't have a free federal system yet, especially in the light of recent case law like Cartesio, which reaffirmed the barriers to free interstate incorporation in the EU. It's not as simple as saying you can just change jurisdiction. And I think that argument is limited. What about the more powerful argument, the triviality argument, or the market failure argument? The government is just mimicking the contracts that we would write with each other anyway when it designs corporate and securities laws. My view, and again I'm open to argument on this, my view is that it gives away a bit too much, because it admits not just the fact that investors occasionally get things wrong, it admits systematic adverse selection by investors. Investors are systematically prone not to rationally protect their own interests. So what this argument does, I think, is it strays too far over a divide between two things. On the one hand, contractual gap filling or market mimicking, which is a legitimate function in the contractarian view. It's a legitimate function of law to fill the gaps in contracts. But when we argue that mandatory rules produce better contracts, we do something more than that. We enter the field, I think, of paternalism. We're saying that private investors cannot make rational selections themselves, so we shouldn't keep rules flexible, because otherwise shareholders would just be duped by managers into accepting a lot of rules which really aren't in shareholders' interests at all, that enable managers to impose agency costs on shareholders. Therefore, we need the mandatory state to step in and help out the poor investors. That, to me, especially in a world with powerful institutional shareholders, sounds like regulatory paternalism, which I think is a different thing from contractual gap filling. So ultimately, if we accept that the state has a direct policy-making function in corporate law, there is a need for a preceding political discussion about the public policy objectives that shareholder protectionism should be designed to serve. And I don't think there's acknowledgement that such a discussion needs to be had. We kind of assume that shareholder protectionism is a force for good without querying why. Now, I was going to respond to this by constructing another theory of corporate governance. I don't think I'm going to have time to do it, so I'm going to flip to my very last slides. Suffice to say, what I'm trying to do is come up with a moral political justification for shareholder protectionism and corporate governance law generally, that tries to add something that's not already there in the debate. But what I would say is, what I believe, my book is titled Corporate Governance in the Shadow of the State. The reason I've called it that is these 3 points. I believe mandatory shareholder protectionism, protecting shareholders, whether through corporate or securities law, is an essential structural precondition for the continuing exercise of quasi-public corporate power outside of direct democratic control. In other words, corporations need to be held accountable. Managerial power needs to be held in check so that corporations can justify their right to exist free from direct democratic control. That's why corporate governance law can be said to operate in the shadow of the interventionist regulatory state. And because of that, it becomes necessary to legitimise and justify the protection of shareholders on political grounds. Can we justify shareholder protectionism on political grounds? In particular, can we justify exclusive shareholder protectionism on political grounds? I'm not saying in rational economic grounds, on political public policy grounds. I think there's a number of issues that can be thrown into this debate. Many people still cling on to the idea of shareholders as having an ownership, a proprietary entitlement to be considered foremost within corporate governance over other parties such as Labour, for example. There's doctrinal difficulties with saying that shareholders own companies, but I think on a popular level that attitude still prevails. We also think of shareholders as being the best people at bearing risk in the company, at least at bearing risk efficiently. Another argument as to why arguably shareholders should be exclusively protected by the law. We think of shareholders as efficient capital allocators, putting money where it's most needed in the wider economy. And also, very importantly, one argument for shareholder protectionism that's very often missed out is the social welfarist function that Adolf Berle famously identified back in the 1930s. If we don't have shareholder protectionism, then what's the alternatives? How are we going to provide a social welfare system? How are we going to ensure that people are able to generate income from savings through non-public means that don't involve public taxation revenues? And I think that's a powerful political argument for shareholder protectionism, but one that very often gets missed, gets glossed over. And I think two other very important reasons for shareholder exclusivity, why shareholders and nobody else are protected through regulation and corporate governance, is first of all in the United States concept, because of the political disenfranchisement of labour. Workers haven't really been seen as a valid concern within corporate governance. Therefore, they've sought protection under external labour law. And in the United Kingdom, where labour has been politically enfranchised, not least through the Labour Party, in the UK, labour as an interest has tended, workers as an interest have tended to seek protection outside of corporate law. They've sought protection through collective labour law, through collective adversarialism, by empowering them through collective bargaining, rather than actually putting workers on the board or giving workers other rights to intervene in corporate decision making. So I think there's a number of factors that explain why we focus solely on shareholders as the sole legitimate concern of corporate governance. I think there's good reasons as to why we do, but I think there's maybe reasons as to why we should look wider. The problem is this political debate people very rarely have, because we don't quite break out of that facilitative, flexible, instrumental mindset that contractarianism instills. So I'm not really trying to put any arguments down people's throats. I'm just trying to come up with another prism, another lens through which to view the topic. So that's really my conclusion. By learning, using and criticising the legal rules from an instrumental or economic perspective, we run the risk of misunderstanding why these rules exist in the first place. And I believe only by understanding corporate law as a political as well as economic phenomenon can we form a proper appreciation of why certain rules exist, and in turn I believe this enhances our capacity to use and criticise these rules on both an academic and professional level. So in short, politics matters, I think, to corporate governance. It shouldn't be seen as a dirty word all the time, and it actually helps us learn the topic. And that's all I've got to say. Sorry I ran a bit over.
No, it's great. Any questions?
Can I just ask, this concept of legitimacy?
Yeah.
I'm not quite clear what exactly you're saying needs to be legitimised.
Yeah.
I think one of your earlier slides said...
I had to gloss over that bit in the middle of that. Legitimacy is, I understand it as meaning a general sense of public rightness, and in developing my understanding of legitimacy, I've delved into a bit of moral philosophy, and I'm always a bit cagey about doing that as a private lawyer. But by legitimacy, I mean mainly legitimacy in the sense referred to by rationalist theorists, people like John Rawls, Alan Gewirth. The concept of legitimacy is tied to the idea of individual liberty and freedom of action. So our individual freedom of action, our autonomy as citizens, should not be interfered with, except in ways which we can exercise direct control over. And one of my concerns with the corporation, from a legitimacy perspective, is the idea that it creates quasi-public power. The legal structure of a corporation is such that corporate controllers, namely managers or directors, have got two very important types of power that they can wield, that they can exercise in making decisions. One of these is allocative power, so they can decide how the company's money is spent, how the company's capital is used, and the board primacy principle substantially insulates managers from outside pressure and outside questioning, more so in America than in Britain. But even in Britain, we still stick to this idea of board primacy. It's just shareholders have got greater powers to intervene from time to time. And also, the law instills another important corporate power in directors and the board, which is appropriative power, which inheres in the ability that the board of directors has to recommend the level of dividend that's paid within the company. Now, of course, shareholders declare dividends, but they can't declare a higher dividend than recommended by the board. So what that creates is almost a kind of what I call a quasi-taxation system. Adolf Berle in his 1950s work famously used this metaphor, the idea that managerial directorial discretion over dividends creates a quasi-taxation system whereby shareholders and indirectly consumers can be taxed for capital expansion. Now, that's how I understand corporate power, and my argument would be without countervailing regulatory constraints which ensure that corporate power is rendered accountable to those directly subject to it. Without those countervailing regulatory constraints, we have a legitimacy problem. We have quasi-governmental power exercised outside of government. And I think that undermines the legitimacy of that power being exercised in the private sector. So when we say, why do we have corporate law rules? I don't deny the efficiency justifications, these exist, but why do we have so much regulation in this field? My argument is we need to understand regulation not just as being facilitative, but actually as solving a political problem, which is rebalancing power between the key actors in the company. You might say, why do we need to see law as being so paternalistic when we have, in the modern day and age, powerful institutional shareholders, powerful intermediaries who look after shareholders' interests? My argument would be we have powerful shareholders, powerful institutional shareholders in this day and age because of the surrounding legal framework that's empowered them. Without that, we would have inefficient companies, but we would also have the illegitimate exercise of power. And I'm sorry, that's very abstract for a corporate and commercial law group, but does that answer your question at all?
I think so, because you seem to be using legitimacy in different ways. So it's legitimising something that the board's part, and then we also have this level of legitimising the shareholder's position. And so it's kind of multi-tiered, is that right?
Legitimising the powers of the board, and I see where you're coming from. I probably also use the word legitimising shareholder protectionism.
Yeah, that's
I shouldn't have used it.
Yeah.
I shouldn't have used it in that second context. I'm glad you pointed that out. I'd rather just drop it in that context. I think politically justifying shareholders' rights, but thanks for pointing it out. Yeah.
Okay, a couple of things. One, so are you legitimating the fact that there's an aggregation of corporate power, or legitimating the actual, corporation? The fact that you can incorporate. A lot of people sort of are concerned about incorporation. Let's get away from that. Say if you turn it into an LLP, so it's not strictly corporate or whatever. Do you also see a concern with the fact that there's simply power aggregated in private hands that has to be legitimated?
Yeah. So I've always used the word legitimising, and I think legitimating is the more common word, but I think you can use them interchangeably. It's not with incorporation per se. One question I've been asked before is, are you just coming up with a contemporary concession theory of the company? The old Victorian, the old pre-Victorian idea that the government gives incorporation. The government creates corporations through the public registration process, so it's entitled to regulate companies as it chooses. No, it's not the act of incorporation that creates the power and resultant legitimacy problem, it's the amalgamation of power. So to answer the other part of your question, yes, they are.
Theoretically, if it all came together just through contract, you would still want to have mandatory rules imposed on a purely, the idea underlying it's an exit contract, so theoretically if transaction costs were zero, these things could exist. You could use the trust or whatever, and it would still be all private, and it would be complicated, but you could get there. You'd want it regulated because it's just a large amount of power in one place.
Yeah, it doesn't matter how the power comes about. I mean, most people tend to assume that irrespective of the regulatory differences in different jurisdictions, there are certain core features that corporations tend to have. So the anatomy of corporate law, classic view that you can have a kind of lowest common denominator of corporate law, and one thing that corporate law tends to have is centralised power in a managerial organ, normally the board of directors. You could get that through contract. You could get it through contract.
You could definitely
whether you had it through contract or whether you had it through regulation.
You think it should be regulated?
It should be regulated because of the power.
It's a major aggregation of economic power. Therefore, you need to legitimize it, and an aggregation of economic power. You need to have regulation.
Yeah, because what I've been mainly concerned with, I mean, I don't want to bang the regulation drum just because the contractarians are banging the deregulation drum, but I wanted to try and explain why mandatory rules exist, and I didn't feel the contractarian defence of mandatory law was quite doing that, and therefore the only way I could come up with a more comprehensive explanation was by going down the power and the politics road, which involves bringing in this moral philosophy, which doesn't always sit that easily with more conventional doctrinal commercial law. But it's about power, really.
I have a couple other points, but by all means, chip in.
Yeah, I'd just like to perhaps supporting your argument that the influence of recent cases of internationalization and cross-border expansion of companies. Do you think that in a way will support your argument of the need for regulation of companies as opposed to just limiting them to contractarian sector?
I think it does two things. I think it supports the argument and it challenges it. I think it supports the argument because when you have cross-border amalgamation of companies, you have bigger companies, creates more power, creates more of a social problem. That's a simple issue. Arguably undermines the view though, because as corporations amalgamate, especially through cross-border merger, very often it presents opportunities to subject themselves to different legal systems. Within the EU, the European companies are the classic example of that. And also, companies frequently merge across borders, and as a result, in effect, part of the combined entity opts into a different legal structure. So in that sense, I could see why my argument would be challenged by that, because the more flexibility we have to subject companies to different legal systems, the more choice, the more facilitation there is in the system. So I don't know the answer. It can cut both ways, I think.
Other points? Okay, well, I'll ask one more now. One thing, if you look at company law over time, it has become increasingly regulatory. So if you've done research, if you look at the LLSV thing and you take it back to the early 20th century, the UK used to score very low. Done work in the US sort of indicates the same thing. Corporate governance didn't exist in the United States as a term until the 1970s. It didn't really exist in the UK until the 1990s. Were companies illegitimate before, say, 1992 in the UK? Or before, let's go push back 1948 when shareholders could dismiss directors, which is pivotal. Were they illegitimate then?
Yeah, well, that's the.
I mean, they were powerful.
Yeah.
You just have to look at. You just have to look at. I mean, you had arms manufacturers, you had General Motors.
Yeah.
They were powerful. Were they illegitimate?
Yeah. I think. I mean, I've adopted an Anglo-American focus. I'm looking at the US and the UK, even though I'm trying to be cognizant of the differences. Look, I think the US is probably a simpler case because you had large-scale agglomerations of capital from the beginning of the 20th century, perhaps even a bit earlier in some cases. You had the railway trust corporations in the early 20th century, and then of course you had Berlin Means writing in 1932 saying corporate power is a problem in the context of the Great Depression. And on the back of the recognition of corporate and financial power as being a problem, two separate issues, we then had the New Deal regulation in the United States, and securities law and banking law, rather than company law, became seen as the solution to a lot of these power problems. So I think in the United States these issues were recognised from an early stage, at least an early stage in the 20th century. Corporate power has been on the agenda. albeit it's maybe come off it at different times. The UK is trickier because we weren't dealing with corporations on the same scale, and also, I mean, as your work has demonstrated, the notion of a widely held company in the UK didn't seem to, I only learned this from reading your work, but didn't seem to become pervasive in the UK until the 1960s onwards. So until then we had entrepreneurial companies. I don't think entrepreneurial companies, in spite of their scale, pose legitimacy problems in the sense that I'm referring to them as, because at the end of the day it's people spending their own money with prudential motives who can be assumed to be using their money for, you know, broadly acceptable purposes. It's when you split up the entrepreneurial presence, when you have separate managers and owners, that's where the problems, I think, that's where the idea of quasi-public power arises. So I'd still say somebody like Andrew Carnegie or somebody like Warren Buffett, they wield power. I'm not saying the power's not problematic, but it's a different type of power. It's manifestly private power, it's not quasi-public power. So I would say, when did it become an issue in Britain? Probably 1992, when Cadbury first took it up.
Well, I'll just make a real quick point. Railways in the UK were huge in the late 19th century. They were fully private. Banks were massive in the UK in the early 20th century. There was a lot of power. Now, railways were regulated, so you could say, but it didn't be regulated by company law. So maybe all it is if you have large agglomerations of corporate power, what you got to regulate it. But is corporate law the vehicle through which you want to do that? So what it would be is you can say you can legitimize regulation on the basis of large agglomerations of power, because that can create difficulties. But why is that company law's role? Why couldn't you do it through antitrust law? Couldn't you do it through other means? So you can make it, so your argument can get you to the point where you could say, sure, you can justify regulation, but why corporate law?
Yeah. I mean, I'd agree that there's all sorts of ways that we can have countervailing pressures, regulatory pressures to corporate power. My main concern is, I'm not so much arguing that we need corporate law to do the regulating and distinction from other areas. It's the fact that we ignore the other areas and we kind of carve out a space within corporate law and say, well, corporate law should be not entirely, but corporate law should be largely flexible and facilitative. Antitrust law is regulatory. That should do the coercive breaking down power stuff. Securities law is regulatory. That should do direct mandatory empowerment of certain people. Corporate law is a kind of vacuum in that sense. It's not viewed to be a regulatory area. And my argument was really, if we view corporate law in this wider framework of regulatory pressures, it's not so easy to draw that dividing line, to say, well, one part should be facilitative and one part should be mandatory, especially when so many areas of non-corporate law, particularly securities law, seem to be now permeating into corporate law. So I've not really answered your question, but I don't necessarily think corporate law should deal with these issues, but my concern is just I don't think we can easily say that it's not doing it, because many areas that we are kind of shutting out the corporate law door maybe should be in the door. Things like securities law is a good example. Antitrust law I've deliberately not thought of because that poses completely different issues, but I think that is something I should probably take into account. I just didn't really want to go there for practical reasons.
Okay, well, it's nearly 2 o'clock, so if we could thank Marc for coming and talking to us, offering a stimulating presentation, great.